Hello and welcome everyone, and thank you for joining us today. My name is Amanda Stedman. I'm BDBF's Principal Knowledge Lawyer, and I'm joined today by my colleague Tom McLaughlin, a Managing Associate in our team. Today we are going to look at 6 issues that we think should be top of your human resources agenda in 2023, before we quickly round up on a few other items that we also think need to be on your radar. Just before we start, there are a few housekeeping points to note. We're planning to speak for around 50 minutes today, and after that there'll be some optional time for Q&A. Today's session is being recorded, but the Q&A section won't be. In the next couple of days, we'll circulate the recording together with a copy of the slide deck that we're using today, and also our 2023 Employment Law Tracker, which rounds up all of the legislative reforms on the horizon. And finally, we are presenting in webinar format today, which means that the best way for you to ask any questions that you have is just to type them into the Q&A box, which you'll find at the bottom of your screen, and you can ask questions anonymously if you'd prefer to do so. We have a lot to cover, so moving on then to our first topic. Where does the law currently stand on long COVID? Well, lockdowns may be long gone, but the legacy of the pandemic continues in the form of long COVID. And we know from our experience of advising clients that long COVID is an issue that employers are having to deal with ever more frequently. And indeed, this is echoed by what we're hearing elsewhere. So, for example, one of the preeminent providers of legal information told us that long COVID was the most searched for employment law topic on their site last year. And indeed, our articles on the subject had the highest readership out of the many, many articles that we published last year. Now, I don't think that this is at all surprising, given that knowledge about the condition is still evolving, and also given that it's not a niche condition. In November last year, the Office for National Statistics published data on the prevalence of long COVID in the UK, which revealed that 2.1 million people, or 3.3% of the population, are reporting long COVID symptoms. So with this in mind, we thought it would be helpful to unpack what we know about long COVID and what it means for you as employers. Now, before we start, let's pause briefly on what we mean by the term long COVID. It's essentially a shorthand term used to describe COVID symptoms that continue beyond 4 weeks from the point of infection. And of the 2.1 million suffering with long COVID in the UK, 1.8 million of those said that they had had symptoms for more than 3 months. And of those, 1.1 million had it for over a year, and 500,000 had suffered from it for over 2 years. So clearly it's a condition that has the potential to have a long-term impact on someone's health. And what exactly does that impact look like? Well, there are a range of possible symptoms, and on the slide you'll see I've set out the most commonly reported symptoms of long COVID. I'm not going to go through them. Safe to say that you'll see it can lead to both physical and mental symptoms, and also that the particular combination of symptoms varies from person to person, and also the symptoms can come and go. All of which means that it's actually quite a difficult condition to identify. So we know it's a potentially long-term condition, and we know that it may lead to an array of problematic symptoms, but does it mean that long COVID should be treated as a disability? I've set out on this slide the test for deciding whether an individual is disabled under the Equality Act. Is long COVID a disability? The simple answer is it could be. So thinking about the first question there on impairment, we saw a moment ago the array of symptoms that can be suffered. And I don't think it will be difficult for an individual to show that they are suffering from a physical and or mental impairment. And jumping to the final question on this slide, I also don't think it will be difficult for an individual to show that they are suffering from a condition that has a long-term effect. As I've said, the majority self-reporting long COVID had it for a year or more. And even if symptoms haven't lasted that long, it shouldn't be too difficult for an employee to show that it's likely to last that long. The real battleground will be on the 2 questions in the middle. Has there been a substantial adverse effect on the individual's normal day-to-day activities? And around 3/4 of the 2.1 million people with long COVID in the UK said that they had been adversely affected in their day-to-day lives. And do remember that, in fact, it's a relatively low bar. It really just means more than minor or trivial. So ultimately, it will depend on the particular facts. But what I think we can say with some confidence is that many of those suffering with long COVID would pass the disability test and so be protected from discrimination at work. And just to underline this, over the last year, the tribunals have looked at this question and agreed that in principle, long COVID may qualify as a disability. So in March last year, in the Matthews case, a tribunal accepted that an employee who had symptoms for about 3 months was disabled on the basis that her overall stamina had declined, she couldn't stand for long periods of time or carry heavy items, and this was, in their view, likely to last for 12 months or more. And similarly, in the Burke case, a tribunal held that an employee suffering from symptoms for about 9 months was disabled. He couldn't do ordinary housework, his overall stamina was affected. However, it's worth noting that in this case, the employee had been dismissed by the employer on the grounds of ill health, and the employer had relied on 2 separate occupational health reports that told them that he was not likely to be disabled. But the tribunal disagreed, and I think this shows the need to treat OH advice on long COVID with some caution. And the final case on the slide there, the Quinn case, actually here the employee was not deemed to be disabled by the tribunal, and this was because at the time she was dismissed, she'd only had COVID for 2 weeks. And so the tribunal said, well, at this point, we can't say it's likely that you're going to have it for a year or more. And that was the case, even though, in fact, she did go on to develop long COVID. Now, surprisingly, it's worth noting that last year, the Equality and Human Rights Commission, the body responsible for providing guidance on the Equality Act, tweeted that long COVID should not be treated as a disability. That tweet provoked consternation in many quarters, including those working in the medical and HR fields. And the EHRC quickly issued what they called a clarificatory statement and said, actually, what we mean is that not every case of long COVID will pass the disability test, but some will. So they got to the right answer in the end. So where does all of this leave you as employers? Well, I think the key takeaway has to be that if you know or suspect that a worker has long COVID, you need to tread carefully because they may be disabled and therefore protected against various forms of disability discrimination. That may be relevant if, for example, you wish to discipline or dismiss on the grounds of ill health. And importantly, you would be under the positive duty to make reasonable adjustments for them. Practically speaking, we'd recommend the following steps. So first of all, promote understanding within your business, educate your managers, members of HR about what long COVID actually is and what can be done in terms of support. The Faculty of Occupational Medicine of the Royal College of Physicians and ACAS have both published guidance for employers, which may be worth having a look at. Before you take any action against an employee in connection with their condition, gather as much information as you can to try to understand whether they could be disabled and the likely prognosis. And linked to that, you will need to think about when to obtain specialist advice. And depending on the facts, it may be appropriate to wait, but keep that under review because you may go from a situation where the individual is not disabled, but over time does meet the disability test that we outlined earlier. If and when you do seek specialist advice, make sure that you ask the advisor to provide a view on whether the individual is disabled by reference to the test. Where the advice that you get back is imprecise, incomplete, or seems at odds with other evidence you have, follow it up and try to get further advice. I think this is a particular risk in relation to long COVID, where knowledge of the condition is still in its early stages. Crucially, though, occupational health reports should not be viewed as determinative, but should be treated as part of the overall picture in deciding whether someone is disabled. As we saw in the Burke case that I mentioned a moment ago, OH advisors may get it wrong. And finally, be pragmatic. Don't be afraid to make adjustments for an individual with long COVID. It will not necessarily be viewed as a concession of disability status, but it may help resolve the issue in hand. And for those with the long COVID, that may include doing things like offering a phased return after a period of sickness absence, providing additional rest breaks, agreeing some sort of flexible working arrangement, whether that's part-time or home working, or possibly even changing the worker's job role or responsibilities on a temporary or permanent basis. So I hope that's helped you understand long COVID a little bit better, and I'm going to hand over now to Tom, who's going to talk to you about flexible working in 2023 and beyond.
Thanks, Amanda. So flexible working reform has been on the cards since 2019, when the government's manifesto committed to consult on making flexible working arrangements the default, save where employers had good reasons not to permit them. And remember, when we're talking about this, that the current flexible working regime is only a right to request and have that request considered in a particular way. It doesn't really make requests that difficult for employers to turn down, although turning down a request may have consequences in relation to discrimination, and more generally leads to you being into a dispute with an employee, even if it's not a dispute in the legal sense. In September 2021, the government published a consultation entitled Making Flexible Working the Default, and it set out a number of proposals for change at that time. The consultation closed in December 2021, and almost exactly a year later, the government has finally published its response and confirmed what changes it will be taking forward. And the response confirms that the government will legislate to make the right to request flexible working a day one employment right. Importantly, as with the current regime, this is not a right to have a particular arrangement, only the right to request one. And it will also back a private members bill, the Employment Relations Flexible Working Bill, which is a private members bill sponsored by a Labour MP. Now, private members' bills don't usually make their way onto the statute book. However, this one has the government's support, and so it seems very likely that it will become law. And the bill will take forward two of what were among the government's original proposals, namely allowing employees to make 2 flexible working requests per year rather than 1, although the bill states that these requests cannot be made concurrently, and reducing the deadline for employers to make a decision on flexible working requests, currently 3 months, and it will be reduced to 2 months. And the bill would also make 2 further changes. It will remove the requirement for employees to explain in their request what effect they think it will have on the employer, and it will also require employers to consult with the employee before refusing a request. And if the employer fails to do so, then the employee could bring a complaint in the employment tribunals. And the logic behind that change is to encourage better dialogue about requests and help the employee understand why the request is not being taken forward. However, employers will not be obliged to show that they have considered alternatives before refusing a request, which was one of the things in play in the consultation. And neither will there be any change to the 8 fixed reasons for refusing a request. And so what steps do employers need to take at this stage? We don't know when the right to request flexible working will become a day one employment right. Legislation is awaited and no timeline has been given for its introduction. The private members bill I mentioned passed its 2nd reading in October last year, and it will now progress to the committee stage for detailed scrutiny. It's not clear when those reforms will come into force, but it's unlikely to be before the first quarter of 2024. It'll apply in England, Wales and Scotland, but not in Northern Ireland. So although there are no immediate changes to be made, given the changes that are likely to occur, it's sensible to be looking at issues of flexible working and hybrid working in your workplace with all of that in mind. If the right to request flexible working becomes a day one right, then it's really going to be a before day one issue, and it will be sensible to assume that questions about flexible working will be raised in job interviews. And so it'd be good to give some preliminary thought as to whether flexible working arrangements are suitable in different roles and what those might be. And thought should be given to asking questions of job candidates about their preferred working arrangements, rather than be taken by surprise with a request later on. But care must be taken not to ask those questions in a discriminatory way. The request process itself will become a bit more onerous because you'll have to deal with them more quickly, and you may have more requests, and therefore employers will want to ensure that their process is streamlined with sufficient resources being allocated to it. We don't think the new requirement to consult before rejecting a request will have much change in practice, because in almost all cases you'll be consulting with the employee about their request. However, you may want to build in time to ensure that you've considered alternative patterns as a way of fending off second requests. The process will be slightly easier for employees in that they don't have to explain the impact of their requests for the employer, although we think in practice many will do so because employees obviously want to sell the request to the employer. Ultimately, line managers will also need to think about the impact of the requests on the organisation, but they need to do that in a way which is fair and objective. And if they don't, and they only take a partial view about the impact, you can land in hot water and be facing potential indirect sex or disability discrimination claims. And in a relatively recent case called Follows against Nationwide Building Society, a highly regarded employee was dismissed after she refused to move from a home working arrangement to an office-based arrangement because she said this would hinder her ability to care for her disabled mother, for whom she was the principal carer. And the employee claimed that her dismissal was indirect disability discrimination by association with her disabled mother. And ultimately, the Employment Tribunal said that Nationwide couldn't justify that dismissal, and key among their reasoning was Nationwide's position that employees needed to work on site in order to be effectively supervised by managers. But in fact, what the tribunal found was that this was simply the subjective view of some managers and was not in fact based on evidence. And so if you're going to be taking a similar position, you need to ensure that you can back it up with evidence in due course. And finally, you'll need to update your policies and practices and training around flexible working to reflect all of those changes. I'll hand you back to Amanda now.
Thanks, Tom. Moving on then to look at proposals to tighten up the law on harassment at work. The government has backed another private member's bill, the Worker Protection Amendment of Equality Act 2010 bill, which is aimed at making some pretty major changes to the law on harassment at work. And again, because this bill has government backing, it stands a good chance of becoming law. We think it's likely to come into force sometime in 2024. However, you should turn your mind to compliance this year. The new proposals concern your liability for sexual harassment at work and also your liability for all forms of harassment which are committed by third parties such as clients or contractors. Now, before we unveil the changes, I think it's helpful to just quickly recap on how things currently stand in those two areas. So first of all, we know that sexual harassment in the workplace is unlawful. Both employers and individuals can be found liable in claims brought before an employment tribunal. However, employers are able to avoid vicarious liability for all forms of harassment, so that includes sexual harassment, where they can show that they've taken all reasonable steps to prevent the harassment from occurring. And in this context, that includes things like having anti-harassment policies, providing good quality and regular training to your staff, and dealing with complaints effectively. So in practice, we know that most employers elect to take those kinds of steps. But the important point here is that there is no legal obligation to do so. So just hold that thought and I'll return to it in just a moment. Secondly, it used to be the case that employers could be liable for harassment of their staff by third parties like clients and contractors. And that was the case where your worker had been harassed on at least 3 occasions. However, those provisions were repealed on the 1st of October 2013, with the result that you are no longer liable for harassment by third parties. So let's turn then to think about what this new bill has in store. So looking first then at sexual harassment, the bill will introduce a mandatory legal duty on employers to take all reasonable steps to prevent sexual harassment of workers in the course of their employment. So covering the workplace, of course, but also things like work-related travel or events such as work Christmas parties. In other words, you're moving to a situation where you will have to take the reasonable steps rather than having the option to do so. But this applies to the prevention of sexual harassment only, and not harassment related to the other protected characteristics in the Equality Act, such as race, sex, or age. For other forms of harassment, the position will stay as it is, namely that you can choose to take reasonable steps to prevent it, but you are not obliged to do so. So what will the consequences be if you fail to comply with this new duty? Well, first of all, if a worker were to succeed in a claim of sexual harassment against you, then the tribunal must go on to consider whether and to what extent you have fallen short. If it were to conclude that you have breached the duty, then it can award an uplift to the compensation awarded to the employee by up to 25%, so not an insubstantial amount. Now, if there's no sexual harassment claim before an employment tribunal, then the tribunal will not have jurisdiction to rule on whether you have breached the duty. Instead, in that situation, the Equality and Human Rights Commission are able to investigate and take enforcement action against you if needed, and that would all be in the public domain. And actually, I think this is quite an important point for you to be aware of when it comes to settling claims of sexual harassment. Because what you're not allowed to do in settlement agreements is gag workers from blowing the whistle about various forms of malpractice. And I think this is likely to extend to suspected breaches of the new legal duty to prevent sexual harassment. The EHRC is a body to whom people can blow the whistle to about breaches of equality law. And so this means that a worker is entitled to make a whistleblowing disclosure to them. So you could find yourself in a situation where you settle a sexual harassment claim, hoping to draw a line under the matter, but the worker would remain entitled to blow the whistle to the EHRC about the alleged breach, potentially leading, as I've said, to an investigation, enforcement action, and of course, unwanted publicity. Moving on then to look at the second aspect of the bill. The bill will make employers liable for the harassment of workers by third parties. And as I said, this covers all types of harassment under the Equality Act. So sexual harassment, of course, but also race, sex, age, etc. And the liability will attach from the very first time that the harassment occurs. And that represents an enhancement on the old position that I mentioned a moment ago, which had said that employers were only liable after 3 instances of harassment. In other words, harassment by a third party will effectively be treated in the same way as harassment by a colleague. And that's potentially quite a significant risk for you as an employer, because it exposes you to claims where the harassment has been perpetrated by someone that you really have no control over. The good news is that the current reasonable steps defence will be extended to cover third-party harassment claims, meaning that where you can show that you had elected to take reasonable steps to prevent third-party harassment from occurring, you should avoid liability. The caveat to that, I should say, is that if the third-party harassment happens to be sexual harassment, it seems to be the case that the new legal duty to prevent sexual harassment that I just outlined would apply. So in relation to sexual harassment, you will have to take steps to prevent it. In relation to other forms of harassment, it's optional. So with all of that in mind, what can you do to limit your exposure? Well, if the bill passes, you need to be able to do 2 things. You need to show that you are doing enough to discharge the new duty to prevent sexual harassment at work, including by third parties, and that you've taken all reasonable steps to prevent other forms of third-party harassment if you wish to avoid vicarious liability for a third-party harassment claim. We know that a statutory code of practice is going to be published. We're not sure when, and that will outline the kinds of things that you will need to do. But we think it's likely that it's going to cover the following types of things. So number 1, you will need to have a really good suite of policies in place the EHRC's existing guidance on sexual harassment already recommends having separate policies for sexual harassment as against other forms of harassment, and making sure that all of those policies cohere with other relevant policies like your disciplinary policy, social media policy, and so forth. Those policies will need to be disseminated amongst your staff. So that means providing copies, or at least signposting copies to staff at regular intervals. And I would suggest before events where you know that harassment has occurred in the past. So, for example, a Christmas party. And also those policies will need to be adapted as appropriate and then shared with third parties, such as clients and contractors. So you might need to have two separate versions of the policy. All of those policies need to be kept up to date. I think you should be diarising at least an annual health check, first of all to reflect any legal changes that have occurred in the last year, but also any trends that become apparent from internal complaints, staff surveys, exit interviews, and that sort of thing. And that sort of links to the next point, which is that you should have methods in place to detect harassment, including third-party harassment. And there's lots of ways you can do that: informal one-to-ones, sickness return to work meetings, exit interviews, as I mentioned. External reporting systems. We know that some employers make use of apps which permit real-time and anonymous reporting of sexual harassment. You will also need to deliver high quality and regular training to your staff about harassment, including the changes that I've outlined when they come into force. We know from case law that you will not be viewed as having taken reasonable steps if the training that you've given to your staff doesn't pass muster. And we think the same approach will be taken in relation to the new legal duty to prevent sexual harassment. So you'll need training that is tailored to the particular audience, but there should be training available of some sort for everyone. And you need to take care that anyone who misses the training when it was provided, due to illness, work commitments and so forth, that they are given the opportunity to catch up at a later date. And finally, very importantly, make sure that when a complaint of harassment comes in, that you're dealing with it promptly and effectively. That may mean taking disciplinary action against the perpetrator. If the perpetrator is a third party, then in some cases, it may mean ending the relationship with them. While there will be work probably for all of you to do, in many cases, it shouldn't be anything radically different to what you're doing already. That said, getting the groundwork done now or in the coming months will mean that you are on the front foot if and when these changes come into force next year. I'm going to hand back now to Tom, who's going to talk to you about new rights for parents.
Thanks. So I'm going to look briefly at plans to introduce two new protections for new parents. The first is in a third private member's bill being backed by the government, which plans to expand special protection in redundancy situations to pregnant employees and those returning from maternity, adoption, and shared parental leave. It's the Protection from Redundancy, Pregnancy and Family Leave Bill, sponsored by the Labour MP Dan Jarvis. It's passed its second reading in the House of Commons in October last year. And if you're thinking for a moment, well, this is very odd. I thought private members' bills were just really forums for raising issues for debate, and they never made it onto the statute books. That's generally right. It is unusual that the government's taking forward its employment law agenda in this way, but that is what it is. If this bill passes, the new protections won't be introduced straight away. Regulations will need to be drafted and lay before Parliament. So although it's not an immediate change, it's one that's really important to know about. Currently, employees absent on either maternity, adoption or shared parental leave get special protection in redundancy situations. And the law provides that before making a woman on maternity leave or an employee on the other types of leave I mentioned redundant, the employer must offer the employee a suitable alternative vacancy where one is available. So in other words, the employee moves to the front of the queue for those sorts of roles ahead of other colleagues. And if the employer fails to do that, the employee may be able to bring an automatic unfair dismissal claim and possibly a discrimination claim. And in 2019, the government consulted on extending that protection to pregnant employees and those who had recently returned to work following those types of family leave but nothing was done about it to implement those changes until now. And so the bill would allow regulations to be made to expand the protection to cover pregnant employees and those who had recently been pregnant but did not go on to give birth, i.e. those who'd suffered a miscarriage or stillbirth, and those who had recently returned to work after a period of maternity, adoption or shared parental leave. And the intention is that a woman will acquire protection from the point that she notifies her employer that she's pregnant. And typically women do this after their 3-month ultrasound scan, although sometimes earlier, obviously, particularly if there has been a history of pregnancy loss or pregnancies otherwise regarded as high risk. And therefore, in most cases, it translates to an additional 6 months of protection, after which point maternity leave will commence and the protection will continue throughout that period. And then the intention is that the protection will apply for 6 months after the return to work. And so, for example, as we put here on the slide, rather than having a maximum of 12 months protection during maternity leave, a woman who notifies her employer in the way I described will have a total period of 12 months protection, 6 months before maternity leave, 12 months maternity leave, and 6 months on return. And the return to work protection will also apply to parents returning from adoption and shared parental leave. It remains to be seen exactly how that will work in practice, because one of the things that the government acknowledged in the initial consultation was that if you take a very short period of shared parental leave, for example, 6 months additional protection after returning from that might be disproportionate. And the precise scope and mechanics of these new protections will be set out in the regulations themselves. So although there's no immediate changes to make in light of the bill, you ought to work on the basis that it will pass and it will become law in England, Wales and Scotland, but not Northern Ireland. And you need to consider the following points. Being mindful that the protection may apply where a woman was pregnant, but then suffers loss of the child. Updating relevant staff-facing procedures and policies on how to manage redundancies, and in training members of HR and line managers who have responsibility for running those redundancy processes. Going to move on now to talk about a potential new right to neonatal leave and pay. Again, it was something the government consulted on in 2019. In March 2020, the government responded to the consultation and said they would introduce these rights, and the same pattern repeats itself, and the government is now sponsoring a private member's bill, this time from a Scottish National Party MP, that intends to make these commitments a reality. And the bill seeks to allow regulations to be made which would enable employees to take leave from day one of their employment where they're a parent of a baby in neonatal care. Again, the precise scope and mechanics will be worked out in regulations, but the bill does provide the right would be to take at least 1 week's leave in the first 68 weeks of the child's birth. That's a minimum. It may end up being more than this. And employees with at least 26 weeks continuous service will be entitled to statutory neonatal pay. Again, the duration and mechanics are to be worked out, but it's probably going to be at the same rate as the statutory pay for all the other types of family leave, which is currently £156 something a week. The bill's completed its passage through the House of Commons and is now moving on to the House of Lords. If it passes, it's expected the regulations won't come into force until 2024 at the earliest. So again, no immediate changes, but there'll be important ones, and you'll need to familiarise yourself with the new framework and prepare internal policies and training on this issue, because it will be a very sensitive time for the employee if it applies to them, and it's not the sort of thing you want to be working out on the hoof at that time. And I'll hand you back to Amanda.
Thanks, Tom. Okay, so moving away from legislative reforms for a moment, we're going to spend a couple of minutes just reflecting on some developments affecting terminations and settlements from the last year, which may change how you do things in practice going forward. So first of all, some new guidance on suspensions. It's not unusual in a misconduct dismissal to suspend an employee during the investigation and or any disciplinary process. But suspension is not without its own risks. It's not regarded as a neutral act, meaning that if you don't handle it in the right way, it could lead to complaints and potentially even tribunal claims, for example, constructive dismissal or even discrimination. Helpfully, in September last year, ACAS published some new guidance for employers on suspension during an investigation at work. When we circulate our follow-up materials, we will include a copy of this for you. The guidance looks at the following areas. So deciding whether to dismiss someone, the process for to suspend someone, the process for suspending someone, supporting an employee's mental health during suspension, and also things like pay and holiday entitlements during suspension. We don't have time today to go through everything that the guidance suggests, but I will highlight a few of the key takeaways, and I would recommend that you have a look at it before taking any suspension decision, not least because anyone that you do suspend will probably know about it. If you Google, "I've been suspended from work," it's one of the top 3 results that comes up. Plus, any worker who seeks legal advice will be told about it. So do have a look at it. So what are my top takeaways? Well, when it talks about whether to suspend, the guidance highlights that suspension can risk breaching the employment contract plus causing stress to the employee. So it recommends only use it when it's a reasonable way of dealing with the situation before you. So in other words, it shouldn't be an automatic or knee-jerk response that you apply to any allegation of misconduct. And linked to that, the guidance stresses it's best to pause to consider whether there are any appropriate alternatives to suspension, which could remove the concern that you have about leaving the employee where they are. So it gives various examples, including things like changing working patterns or duties, perhaps moving the employee to work in a different team, or possibly directing them to work from home or another location if you have one. The guidance also recognises that sometimes external bodies may be involved in your process, perhaps conducting their own investigation. So, for example, the police, if you've got a potentially criminal matter before you, or a regulator, if there's been a potential regulatory breach. And the guidance again underlines that you shouldn't take any knee-jerk decisions on the basis of a third-party involvement. It shouldn't be the case that an external investigation automatically leads you to suspend. Rather, it's just one factor that goes into the mix, whether it's relevant to your own investigation and whether it means a suspension is the reasonable response. In terms of getting the process right and offering support to suspended workers, the guidance has a number of useful tips. I don't have time to go through them all, but there are 3 that I think are just worth flagging. So first of all, it recommends that you allow employees to be accompanied to any suspension meeting. Now, that is not a statutory requirement, but it is considered best practice. And I think it's pretty hard to think of a reason why it shouldn't be permitted. When you are in the process of suspending someone, explain clearly to them the reason for suspension and also why alternatives have not been deemed suitable. Be very clear that it doesn't mean that you've made any decisions, that they've done anything wrong. That's a really important point to convey to the employee so they have faith in your process and don't later assert that you've already made up your mind and the whole thing is a sham. And finally, one perhaps you're aware of already, make sure you keep the suspension as short as possible. The longer it goes on, the higher the chance that the employee's well-being will be adversely affected. Being suspended is incredibly stressful, and the more likely it is that the relationship could then break down. So keep it as short as possible. Once they are suspended, keep that suspension period under regular review. So to sum up then, the key takeaways in a nutshell are: consider any proposed suspension on a case-by-case basis. Don't jump the gun. If you do suspend, manage that process carefully and be supportive to the suspended employee. So do have a look at that before you suspend anyone. Moving on then to settlement agreements. And we think you should know about a recent decision which looked at how claims can be waived in settlement agreements. So if you have an in-house template settlement agreement that you use, you may need to think about updating it in light of this decision. In this case, the employer notified the employee, Mr. Bathgate, that he was at risk of redundancy. They offered him settlement terms, which he accepted. He entered into a settlement agreement with them, under which he settled all claims against them. In exchange, the employer agreed to pay notice pay and redundancy pay. So far, so normal. However, the employer also agreed to pay what was described as an additional payment, and that was to be calculated by reference to the terms of a separate document, a collective agreement. However, the employer later discovered, when it looked at the collective agreement, that the additional payments were actually only due to staff who were below the age of 61. And it turned out that Mr. Bathgate was already 61 at the time of his dismissal. So with that in mind, the employer decided it wasn't going to pay this additional payment to him. And they only notified him of this around 5 months after he signed the settlement agreement. As you can imagine, he wasn't too happy about this. And he said that the decision not to pay him the payment amounted to age discrimination. The employer accepted this, but said, well, I'm afraid that's tough because you've waived all your rights to pursue claims against us, including for age discrimination, pointing, of course, to the settlement agreement. The Employment Tribunal agreed with them, and so Mr. Bathgate took this up to the Employment Appeal Tribunal, and it's the decision of the EAT that's of interest for you. So the EAT concluded that in order for a settlement to settle a claim under the Equality Act, it must relate to a particular complaint, and they looked at what that meant. They said it could include actual claims that have been brought before an employment tribunal. It could also include known complaints which haven't been brought before a tribunal, but where circumstances existed which could give rise to a complaint. For example, matters that had been raised in an internal grievance. However, in their view, it didn't include unknown complaints about things that may or may not occur at some point in the future. To allow settlement of unknown claims, they said, would expose claimants to the risk of signing away their rights without understanding what they are doing. It also didn't include any claims covered only by a general waiver clause. And a general waiver clause can take the form of what's known as a blanket waiver, which is wording that seeks to waive all and any claims in any jurisdiction, etc. But they can also take the form of waivers which take the form of a long list of all legal claims, so-called kitchen sink waivers, because they contain everything but the kitchen sink. And the EAT said that these types of general waivers don't work. There has to be some kind of detailing of the claim that the employee is being asked to give up. So where does this leave you? Well, in our experience, it's common to specify both the particular claims that you're concerned about in a settlement agreement, but also hedge your bets by including a kitchen sink waiver or a blanket waiver, or indeed both. And you can continue to do that in the hope that it deters claims, but just make sure that you're not putting all your eggs in one basket and relying on a general waiver. So do particularize the claims and complaints that you're really worried about. And remember, of course, that employees will not be barred from pursuing statutory employment claims which are unknown at the time of entering into the settlement agreement. And the EAT acknowledged that that may be inconvenient for parties who are really looking to have a truly clean break from each other. But essentially, they said that that is tough. Now, that said, there are certain things that you can do in your settlement agreements that can deter individuals from bringing unknown claims. We don't have time to go through them today. If you'd like to know any more about what that looks like, please do get in touch with us after the webinar. And I'm going to hand over to Tom now, who's going to talk to us about the revocation of EU-derived employment law.
Thank you, Amanda. So I'm going to be addressing the so-called bonfire of EU law that you no doubt heard about in the press. And in September last year, the government published the retained EU law revocation and reform bill, the purpose of which is to remove the presence and influence of EU law within the UK, and it'll affect all areas of law, including employment law, and could lead to very significant changes to employees' rights by the end of this year. To fully understand it, you need a a 30-second primer on the structure of EU law. So bear with me, and this is it. A large proportion of our legal framework, including employment law, is underpinned by law from the EU. And it comes in three flavours. EU directives that had to be implemented into UK law, either as an act of parliament, such as the Equality Act, or as a statutory instrument, sometimes called secondary legislation, or sometimes called regulations, such as the working time regulations. And that's the far left boxes there on the slide. Certain other forms of EU law applied directly in the UK without us having to do anything. And in particular, Article 157 of the Treaty on the Functioning of the European Union, which is relied upon in a lot of these equal pay shop worker claims you see going through at the moment against the big supermarkets. And then finally, on the right-hand box, the decisions from the EU courts, the Court of Justice of the European Union, which were binding on us as well. And Brexit required changes to be made to that framework, and acts of parliament would just remain in place, although parliament in theory could repeal them with a new act of parliament or change them. But the other statutory instruments would have fallen away automatically when Brexit happened. To avoid legal chaos in that period, the government chose to preserve those things and keep directly applicable EU law and decisions of the Court of Justice and all of those regulations, and are now known as retained EU law. And it's these bits in the boxes which are now coloured red, so the secondary legislation, the regulations, and the directly applicable EU law, which are now up for being changed as part of this new bill. And the bill provides that all of those will automatically expire at the end of this year unless a decision is made to preserve them. And this is called sunsetting. And it's not very common in English law. You do see it a lot more in other places, such as the US. And any retained EU law which is kept will then be assimilated into UK law. But there will be a downgrading, if you like, of the way that European court decisions are treated, and the courts will be, it'll be easier to depart from those. However, the rub with all of this is the question about which laws will be kept and which will be sunsetted is as yet unanswered. And could be very significant changes to employment law and the whole UK legislative framework. The government's own estimation is that there are 2,400 pieces of legislation potentially affected. Retained EU law affects areas like working time, transfers of businesses and outsourcing, atypical workers' rights, such as part-time workers, agency workers, and certain information and consultation rights. And in theory, all of those could fall away by the end of the year. It all depends on what government departments and the devolved administrations decide will be kept. So we have gazed into the crystal ball, and here are guesses of areas which might be up for change as part of this process. Firstly, the working time regulations that covers paid annual leave, rest breaks, restrictions on the amount of working time. It's hard to imagine there'll be a complete deregulation of all of that. But we do think the rules around the 48-hour limit on working time could be changed or abolished. And so the need for opting out of that could well go. And we could see changes to the way that holiday pay is calculated, because a lot of EU case law has meant that other elements, in addition to normal pay, such as bonus and commission, which have to be taken into account when calculating holiday pay, that could be revised, and holiday pay could end up being basic pay only. So-called TUPE transfers, the transfer of undertakings, protection of employment regulations, applies to business transfers and outsourcing situations, and it provides that employees automatically transfer to the new owner or the new provider with protections against unfair dismissal and against changes of terms and consultation requirements. And again, total deregulation, quite unlikely, but we do think potential for new rules allowing harmonisation of terms after a transfer. And that was one area which businesses reported was very problematic when the government reviewed TUPE in 2013. Agency workers, the agency workers regulations, actually one area that could go all together, we think. And businesses complained that complying with those, and in particular the rights to give agency workers certain comparable terms after 12 weeks with a hirer, businesses complain that that is burdensome to comply with. So what does it mean for employers? Could mean nothing, could mean a complete rewriting of employment law. And we will obviously keep you up to date on our newsletter. And so if you're not a subscriber to that, make sure you subscribe. I'll hand you back now to Amanda for a final roundup.
Thanks, Tom. So just in our last couple of minutes, I'm going to give you a very super quick roundup of a few other items that should just be on your radar for the year ahead. So first of all, there are plans to give employees a day one right to take 1 week's unpaid leave in order to provide or arrange care for a dependent who has a long-term care need. So that will cover anyone who cares for a spouse, partner, child, parent, or other dependent who needs care due to a disability, old age, illness, injury, that will require at least 3 months of care. For those of you operating in the hospitality sector, you should know that there is a bill going through Parliament which will require employers to ensure that all tips, gratuities and service charges that you receive or exercise control over are paid to your workers in full without deduction. The bill will also introduce obligations to ensure the fairness of arrangements to distribute the tips amongst workers, either directly by you or via an independent trunk arrangement. There will also be a new code of practice on tipping, which will provide some guidance on how you do this. And you will also be required to have a written policy on how tips are dealt with in your business. We don't have time to unpick this today, but if any of you working in that sector would like to have a more detailed discussion, do get in touch with us after the webinar. And finally, a few consultations just to know about. The consultation on statutory code of practice on fire and rehire practices was actually issued just a couple of hours ago. And so this, you'll remember, is rooted in the dismissal of 800 staff via a pre-recorded Zoom call by P&O in March 2020. That was widely condemned and put the practice of fire and rehire directly under the spotlight. And in response to that, the government said it would publish a statutory code of practice which set out how employers should consult when it wished to change terms and conditions of employment. As a statutory code, tribunals and courts would be required to take it into account when considering relevant cases. And if you didn't comply with it, they would have the power to apply an uplift of up to 25% to any compensation awarded. So that, as I said, that code has just been published this morning. I haven't had time to digest it. Safe to say that it's open until the 18th of April 2023. So it's unlikely, I think, that the code will come into force until the latter part of this year at the earliest. There's another consultation being run by the Prudential Regulation Authority and the Financial Conduct Authority regarding proposals to abolish the cap on bonuses for bankers. The cap limits variable pay for material risk takers to 100% of their fixed pay, or exceptionally 200% where there's shareholder approval. Under the proposals, firms will still be required to set an appropriate ratio between fixed and variable pay for key individuals, and the variable pay will still be subject to rules which require things like payments to be deferred over a number of years, a proportion to be paid in non-cash instruments, and the application of malice and clawback rules in certain circumstances. But aside from that, the cap will go. So we will see a probable increase to the amount of bonus awarded to bankers. That consultation closes on the 31st of March. If the cap is abolished, it will take effect, we think, for most firms from the 2024-2025 performance year. And just not on the slide, but separate to this consultation, we also know that in the financial services sector, there are plans to open a call for evidence on reforms to the senior managers and certification regime. On a last check this morning, that still hasn't been published, but it is due imminently. And finally, on the slide, the government opened a consultation earlier this month on holiday entitlement and pay for part-year and also irregular hours workers. And this follows the decision of the Supreme Court last year in the case of Harper Trust and Brazil, which said that part-year workers are entitled to 5.6 weeks annual leave per year, regardless of how many weeks they actually work in across the year. That effectively means that part-year workers get proportionately more holiday entitlement than a full-time worker. And so in a nutshell, what the consultation is proposing is a reversal of the conclusions reached in the Harper Trust. If implemented, what it would mean is that you'd be able to return to prorating holiday entitlement for part-year workers. That consultation has a closing date of the 9th of March 2023. So for all of those consultations, if you'd like to respond to any of them on behalf of your organisation, you've got plenty of time to do that. And I think that is the final point that I had to mention. So that brings us to the end of today's webinar. We do hope you enjoyed it and it has helped you feel on top of what lies ahead in the coming months. On the slide, you'll see our contact details. Please do feel free to get in touch with us in connection with anything that we've covered today, or indeed anything else.